I stand not with this decision. General Musharaf, he is the guy. He boosted economy, offered lots of opportunities. He has been defending Pakistan in all the circumstances with all his spirits. Hello and welcome, ladies and gentlemen. This is Dr. Muhammad Ali Hamza and I have with me Mr. Asad Butt, the renowned lawyer. And after a long time, we are in discussion with Mr. Asad Butt. I'm sure, Mr. Asad Butt, everything is okay and we'd like to know what happened. Why was there a gap? But that's a later question. The present question that is in our mind is about a verdict that came from the special court and that actually sentenced a death order for ex-president and General Pervaiz Musharaf. We need to know a legal perspective about the case and we'd like you to highlight certain issues. We need to understand the first thing, that the case was about being a traitor. What is the definition of a traitor in the legal perspective?
Well, it's a very broad definition. In fact, we need to understand that not only the traitor is one who is actually, abrogating something, but in the real sense, who's abrogating the Constitution of Pakistan. So in this regard, the court was right in taking this case when the Pervaiz Musharaf in 2007 actually imposed an emergency. So the President Musharaf was supposed to state before the court what were the circumstances which have been allowed,
compelled him
and which are legally allowed and constitutionally allowed to impose the emergency. So I think that President Musharaf was not able enough to state before the court because he was out of the country and the trial was conducted which is we call trial in absentia, trial in absence, that he was not able to state before the court all the evidence which compelled him, all the people and all his cabinet which he was having at that time,
right?
Which advised him that these are the circumstances you are supposed to.
This is Mr. Asad Butt is one side, that he was not given a full liberty to defend his case. I'll get back to that definition of traitor, but please let our viewers understand the development of this entire process, this entire case. How was it developed? How the bench was made? And isn't there any certain biasness involved in the entire process?
Well, to a certain extent, yes, there are some kind of biasness because the court was in hurry. Court was supposed to be following certain kind of directions because court did not, and special court did not follow the laid down principles, because when you are conducting trial in absentia, you are supposed to give the right of hearing to the lawyer or the counsel of the accused at least. But in this regard, we see that no right was given to the counsel of the accused to state what were the circumstances. Even certain applications were filed before the special court that the government wanted to make certain other persons as a party to these proceedings because they were involved, like Shaukat Aziz and like the then Chief Justice of Pakistan, Dogar Saab. They were all involved, but all these applications were actually turned down, and court seems to be a little bit in hurry.
So it is a very popular saying, hurry is to bury the justice, isn't it?
Yes, that is. We need to maintain an equilibrium, a balance between, you should not be so much hurry.
Why was the court in hurry?
Because I'm not able to understand, because if you take the side of the court, we see that numerous opportunities were granted to the President Pervaiz Musharaf to state or to get his statement recorded under Section 342, which is the mandatory when the accused is there. He actually states through statement 342 his stance, what he's feeling, what was the circumstances, and whole the scenario. It's actually the stance of the accused, which is stating that he's not guilty, he's innocent, and these were the circumstances which compelled him to impose an emergency. But somehow the president was not able to come in this country and got his statement recorded before the court.
Do you think, beside the verdict that has come before, do you think there was some a kind of a revenge from certain parties that has been displayed through the court?
That was the trial in absentia, which means trial in the absence of the accused. But I still believe that at least the lawyers of the accused should have been given the right to state something, but they were denied.
They were denied the right.
This is unprecedented. At least if we are about to set certain precedents, about to set certain examples, which are about to...
So you, being a lawyer, you observe and you see some unprecedented acts from the side of the court as well.
Yes, because that is a special procedure. We need to understand this was a case of high treason. Article 6 of the Constitution and the high treason.
It's a sensitive case
Act
indeed.
1973. You are going to punish the accused for the ultimate
penalty.
Death penalty. So in this regard, all the formalities and the
Has to be accommodated
has to
well.
be accommodated, because no one can question.
I would like you to throw some light on the bench that has decided or gave this verdict. The making of that bench, how do you see that?
Yeah, it was formulated back in 2012 when there was an era of Nawaz Sharif, and it is actually argued and alleged that since the Nawaz Sharif has some sort of
Influence.
grudges against the
Influence on some.
And that he formulated this bench, and after that certain petitions were filed in the apex court, and the apex court decided to hold this bench for one reason or some another reason.
The bench itself seems to be from certain angles as influenced by some political revenge. All right, now please let us know from the legal perspective. Now this case will be taken to the apex court. How would the apex court look at it?
Obviously, apex court is the ultimate court of the country, and that court will actually look into the detail of the matter and always also look at the nitty-gritties of the legal requirement which have been neglected by the special court. So of course, when
this will not sustain,
I
the
believe,
verdict will not sustain.
I believe that will not sustain, because there are so many things.
Lacunas are there?
Lacunas are there because the statement of 342 is not there. Trial was in absentia. The counsel of the accused was not given an opportunity to state before the court what were theirs, what were the circumstances, and numerous applications were there. When you file an application in a trial, first the application is decided, then the trial will go on. But in this scenario, we see that the application were neglected. This was unprecedented.
Okay, now take this discussion from the political, from the legal perspective to a general perspective. Let's talk as Pakistanis. I mean, I have observed and seen Mr. Musharaf, General Musharaf, fighting and defending Pakistan at every platform. He has been talking in India before Indians and defending Pakistan. He has been talking to the Westerns and defending Pakistan. I mean, how could the person, I'm not giving an example of his involvement in Kargil or in wars, but as a defender, he had been defending in the platforms, journalistic platforms, political platforms. How could he be a traitor?
Well, we need to understand when the matter is before the court, we have to see constitutionally and legally. When you abrogate the constitution, when you actually try to jump over the provisions of the constitution, you actually stopped the procedure which was going democratically. There were certain parties which were coming to the power, and you actually stopped.
Now here
them.
comes the catch. You can call it an inadequate act, but how a treason? I mean, the statement came from DGISPR that how could he be a traitor? And he's absolutely right, because there could be an inadequate action. There is a hell of a difference between an inadequate action. The orange train, to my perspective, is an inadequate decision. But inadequate decision, how could call it an act of treason?
Well, we need to understand when you are in a court, you have to speak legally. You have to speak constitutionally.
Is law illogical?
No, not if it isn't illogical, you need to get it amended through the legal
Here
procedure.
it sounds illogical. I mean, a person, for example, the Dawn leaks. a person who did the Dawn leaks, he was a traitor because he sold out certain secrets. You know, the Mamogate scandal? In that case, there was a case of treason.
Well, there are different aspects of looking at the matter. But again, when you are in a court, you have to state before the court reasons why you promulgated the emergency, why there were certain reasons you stopped the democratic procedures.
The court could look into, for example, let's talk about the abrogation of the Constitution. Number one, the Constitution is not the the word of a god. It's not something divine. It's the man-made thing. It could have problems. Number two, don't you think that when somebody abrogates a constitution and you consider it illegal or you consider it inadequate or not appropriate, and as you said that he was the accused was given six options or six times a opportunity to give its defense, still you cannot call it an act of treason. You can call it an act of inappropriate decision making or inadequate action. How could be a treason? Don't you think a person like Nawaz Sharif, who was 3 times Prime Minister, and he was talking about Bombay attacks and he was accusing Pakistan?
I believe that even if President Musharaf was actually accused of committing some sort of treason, he should be allowed to state everything before the court. Procedure lapses are there. His lawyer was not allowed to speak.
Do you think running a case of treason was itself a malicious act?
Yeah, it was, because the Nawaz Sharif was actually the victim of his emergency. So that's why I believe that it was somehow a malicious act. But court should be allowed both the party to come before the court and given an opportunity.
Wasn't
to
court
speak.
responsible to look into the malicious formulation of the case?
Because the government is changed now. The next government is also taking the same stance. But the same government is not given an opportunity to state before the court what were the certain reasons. And different other parties should have also been made the parties before the court, and they were equally responsible for that.
Few quick things. Please give your response. Dawn leaks, Mamogate scandal, Nawaz Sharif talking about Bombay attack and saying that we are responsible for that. Let's talk about the corruption charges. Do these all come under the act of treason?
Yes, they are, but we need to have courage to state before the court. Somehow, on one reason or another, we are not taking to the court. Court is actually asking this time. I believe that the courts are independent. Courts are taking a courts where they are inviting the application to come before them.
Where is the suo motu then?
Suo motu is actually another.
Why can't an apex court go for a suo motu on Dawn leaks or on other things?
Well, we need to understand that different judges come as a apex seat of the court, apex seat of the apex court. So they differs from one person to another. We have seen there are so many judges who are very eager to take suo motu actions. But this time we believe that this time the justice, Honorable Chief Justice, is not willing to take suo motu action. Mm-hmm. So we see that the nature.
But they invite applications. So we should
welcome.
Get up. They welcome.
They welcome.
So we should get up against people who are behind Dawn leaks, people who are behind Mamogate scandal, people who are behind, and we should put up the applications.
Yeah, if we put up the application before them, obviously they will take notice of that, but they will not take themselves take the notice of that.
All right. Now let's go to the conclusive part. I would like to take your opinion on the impact of this decision, how this verdict of the special court have an impact in future. What are the benefits? What the benefits you foresee, and what are the negative outcomes you foresee?
The negative outcomes, of course, are that the procedure was not strictly followed, and I'm not able to understand what was the hurry in order to conclude this trial. Mm-hmm. This was actually the negative.
So you're unable to understand that?
Yes, unable to understand. This is actually unprecedented. and of course it will help the accused in the apex court before the accused will file and his team will file an application or the procedure will take place. But the positive aspect is that it will also give a message to all these institutions that do not try to abrogate the constitution.
Cross the boundaries.
And if you abrogate the constitution, you have to be answerable and you have to be prepared for that. You need to have certain ground to tell before the court, these were the circumstances which compelled me, and I would only be responsible to state before the court.
Mr. Asad, thank you very much for your time. But at concluding this talk, I stand not with this decision because I know General Musharaf, who might have made lots of mistakes in his decisions, who might have taken some inadequate decisions that I might not agree. But I know this thing very clearly. He is the guy who actually controlled the economy, boosted economy, offered lots of opportunities to our country. And as well, after his retirement, after 2008, he has been telling the world, showing the face of Pakistan that is positive and defending Pakistan in all the circumstances with all his spirits. Thank you very much for watching. Thank you, Mr. Asad. Pleasure talking.
Same here.